behalf of all the co-host associations, welcome you all to the virtual meeting on very important topic on analysis of Safari retreat by Supreme Court for India. By a very eminent and well-known personality in the GST fraternity, CA Rajender Arora ji from Delhi. Before he start his presentation, I request our President Kiran Sawar sir to say a few words about the association. Over to you, Kiran Sawar sir.
Good afternoon, everybody. It is my pleasure to welcome you all to today's webinar on analysis of Supreme Court judgment of Supreme Safari retreat by our learned speaker, Sri Rajender Arora sir from Delhi. Friends, though the government says that GST is simplex and very good taxation, it is the maximum litigations on board. Legitimate ITC is also denied by every department on one or other ground, and hence this case is very important for us for the study purpose. One of them is this case was allowed by the Supreme Court in last month for the Safari retreat. We, Tax Practitioner Association at Thane, in collaboration with Tax Friends Association Mumbai, North Maharashtra Tax Practitioners Association, and Taxation Consultant Association Sangli, delightly to have such diverse group of the participants for today's event. I would like to take a moment to express my gratitude to each one of you for being here. Your presence signifies determination to learn. Today's webinar is briefly to learn and to network. We hope by the end of this session, we will leave with new insights and valuable connections. Towards the end of the session, we'll have a question answer session with a learned speaker, where I encourage you all to engage actively and sharp your knowledge and share your thoughts. Your participation is what will make the event truly enriching. Thank you everybody for joining the webinar. And now we will start the webinar in a minute.
Thank you, Kiran bhai. Before I hand over the mic to the learned speaker, I request Vijay bhai to say a few words.
Thank you, Arvind bhai. Friends, I think Kiran bhai has said it all. I would at the outset like to thank our speaker Rajender Arora, who on my one call he readily agreed to come and explain us this important judgment by the Supreme Court. So thank you, Rajendra bhai, and I would like to thank all the joining associations also. Just to give a brief about Tax Friends. Tax Friends is a 47-year-old association which was just formed by a few friends coming together, but then slowly it has grown, and today we have a national presence with our own YouTube channel. And we have most of the stalwarts like Vikram Nankani, you can name it. DM Harish was our former member, Nari Gursani was a foreign member, Vikram Nankani is a current member, Jagdish Nankani, past national president of AFTP or GSTP, past presidents like Anand Panjwani, all they were members. So we have a good collection. Thank you. That's a brief about it. Thank you very much for giving me the opportunity.
Thank you, Vijay bhai. We all know the Rajendra sir from Delhi, but as a protocol, I request our committee member Sanjay Savla to kindly introduce Rajendra sir. Over to you, Sanjay bhai. संजय भाई आप म्यूट हो संजय भाई अनम्यूट करो अपने आप को Vijay, kindly unmute Sanjay Savla.
Thank you, Arvind bhai. Good afternoon, friends and seniors in profession. First of all, I thank you, Tax Practitioner Association and all other joint participants to giving me this opportunity to introduce CA Rajender Arora. He is president of GST Research Foundation. He is a deputy convener of CSL BJT Delhi Pradesh. He is vice chairman Delhi North Zone AIFTP 2024. He is chairman of GST Study Circle North Zone AIFTP 2024. He is managing partner in Spark and Associates Chartered Accountants LLP. He is chairman of GST Committee of NIRC of ICAI for the year 2021-22 and 2019-20. NICSA chairman of NIRC of the ICAI for the year 2019 and 20 and 2016-17. Treasurer of NIRC of the ICAI for the year 2018-19. Secretary of NIRC of the ICAI for the year 2017-18. He is member of Delhi STBA, AIFTP, BCSA, CJPI, and MTPA. He is TIOL award-winning faculty. He is acclaimed YouTuber. Channel name CA Rajender Arora. He is lead trainer, consultant, author, and counsel in GST. He is known as GST Guru, GST Chanakya, GST Champ, and GST Rajendra. He is working toward mission GST literacy. He is president of Association of Taxpayer and Professionals, Delhi State. With this brief introduction, I welcome CA Rajendra Arora ji.
Thank you, Sanjay bhai.
Thank you.
Thank you, Sanjay.
Welcome,
bhai.
Rajendra bhai.
Thank you, Sanjay bhai. Before Rajendra sir start his presentation, I would like to say that this program is live on the YouTube. So I will request all the participants kindly subscribe to our channel and like this video. Thank you. And over to you, sir.
Thank you, sir. Thank you very much. At the beginning, I would like to all the organizations combined together who have been catalysts to organize this particular program. Special thanks to Vijay Keval Ramani sir and Kishore Lula ji and all other managing committee members of all the participating organizations. And yes, special thanks to all the participants of this program also. Friends, the topic which is being kept today is for the analysis of this Safari Retreat judgment, which was delivered by the Honorable Supreme Court. And this judgment has created much hue and cry in the professional arena by all the stakeholders of the profession, of the economy. This judgment has its roots back in 2018, when originally the judgment was delivered by the Honorable Odisha High Court in case of Safari Retreats Private Limited. And then the judgment was being allowed, or I would say the applicant's contention was being allowed by the Honorable Odisha High Court. Thereafter, it was being challenged by the Government of India, Union of India, and went to the Constitutional Bench of the Supreme Court. Thereafter, since 2019 till now, for almost more than 5 years, the decision was pending with the Honorable Supreme Court with respect to this particular judgment. This is the chronological order of the developments into this particular judgment. Now question arises what is the issue all about? How it was actually started? What was the original issue? So, friends, when in 2018, Honorable Odisha High Court received a writ petition, and the issue was with respect to the non-availability or blocking of the input tax credit by way of application of the provisions mentioned in section 17(5), subclause C and subclause D. It is with respect to 17(5). 17(5) is a section, 17 subsection 5 is a section which is talking about the blocked credit, the instances of the input tax credit which are blocked and the taxpayer cannot avail it. Out of those clauses, section subclause 6C and D are talking about the input tax credit with respect to the construction activities. Subclause C is talking about the construction activities got done by a taxpayer through the outside contractors like the works contractor or other contractors. And subclause D is basically talking about the construction activities. The input tax credit of such construction activities are accumulated. Such construction activities are done by the taxpayer itself on its own account. Thereby, the input tax credit again is restricted or blocked or not allowed. Now, what happened? This is the background, the legal background of the situation, which was there before the Honorable Odisha High Court. Now, the factual background before the Honorable Odisha High Court was that this safari retreat, the applicant, the safari company, the applicant was involved in construction of malls. Like the malls, normally we see that display of various brands, the showrooms, and under one roof, including the food courts, including the other services, goods, everything under one roof. So this company was involved, the applicant was involved in construction of such malls and giving such malls on rentals to such other brands which showcase their products, goods or services, and make available for sale to the visitors coming to that particular mall. Now, question was before the safari that they constructed a mall wherein they accumulated the input tax credit on the inward supplies. They got it done on their own. Please be with me very carefully because I always try to choose words which are either guided through the statute or by the jurisprudence. So wherever, friends, you have to go with very carefully with every word I use, the every phrase I make. I always make this declaration at the beginning itself that one must not miss various words used or phrases used by me because almost 99% of them are being borrowed from the statute book or the directions given by the jurisprudence through various case laws, through various delivery of various judgments. So Safari was involved in that construction. They got that construction done by themselves, receiving inward supplies of goods or services. On those inward supplies of goods or services, they accumulated the input tax credit of around 34 crores. And they got it adjusted. The department, the adjudicating department, did not allow. In response to that, they went to the writ court under Article 226 of the Constitution before the jurisdictional High Court, Honorable Odisha High Court. So the uh, the contentions made by, listen to me very carefully, because I am creating, when the liberty is given to me to deliberate the case in my own words, I would say that in my own way of narrating the entire story, I would be narrating the entire story in my own way, using the same phrases and words used by the court, Honorable High Court. Now they went to the Honorable High Court with this on this pretext. The Honorable High Court started analyzing, and they went to far ahead in analyzing this particular. I'm just talking about at present the analysis of the Honorable High Court, which was done in 2018. Then, because unless you do not remember, you do not come to know, this is the sequel. Now I'm taking you to the prequel of this movie, this episode. So the prequel is with respect to, of course, now there is a sequel and another sequel shall come. Like Kishore Bhai was asking me that directly tell us that what is going to be the judgment delivered by the Honorable Odisha High Court. So first I will take you to the prequel. What happened before? What happened today? Itihas. So Honorable Odisha High Court examined the entire matter and they deliberated at a greater length, and they pronounced in the open court, and they laid down certain, I would say at that very moment also, what to talk about, what is being delivered in 91 pages by the Honorable Supreme Court, that is so much ahead of time. But even in 2018, the Honorable Odisha High Court also delivered a masterpiece, a beautifully structured and carved out judgment. What they said was that some investment is made, and out of that investment, an asset is created. And that asset, which is created out of that investment, is being put to use and generating revenue, and that revenue is subject to GST. So the Honorable Odisha High Court way back at that point of time categorically established a chain of revenue generating activity, that whatever is being created by way of investment is going to generate revenue which is subject to tax. So this is a continuous, unbroken, unbreakable flow of revenue and tax thereon for the exchequer. Therefore, the input, listen to me very carefully. Therefore, the input tax credit which is available on all the inward supplies, not only 17.5 CD, but on all the inward supplies which is available to create that asset to generate revenue for subject to tax, would be available not only for C&D, but for all the inward supplies which are used to create that asset. That is what the judgment was delivered, the crux of the judgment, which was delivered by the Honorable Odisha High Court. But because in this particular judgment, the Honorable Odisha High Court read down the provisions of 17.5 CD, or in other words, they said that it should not be read in the law itself. We should stop reading it. It means that is not there. So in response to this, the union went to the Honorable Supreme Court before the Constitutional Bench. And thereby, it was now subject matter of analysis and examination by the apex court of the country. And thereafter, the judgment of Honorable Supreme Court was delivered in the month of October. And now we are here to take this journey forward after the conclusion of the first event, that was the delivery of judgment by the Honorable Odisha. Now it went to Supreme Court. Okay. Now what Supreme Court delivered, what Supreme Court said. Before that, in brief, I would like to tell you the charges framed by ASG, Additional Solicitor General, on behalf of Union of India. The moot question which is being framed by the applicant, that in 17.5C, the word which is used, there are two exceptions. I would rather say, there is an exception in both 17.5C and D each, that the credit shall be available. In C, the law says the credit shall be available to plant and machinery. In D, law says that credit shall be, exception is designed, the credit shall be available to plant or machinery. And the applicant side, the safari side, Honorable the learned counsel, Mr. Arvind Datar, presented that the plant and machinery and plant or machinery, the definition, or rather I would say the meaning of plant and machinery is there in the law in 17.5 section only by way of explanation. But the meaning of plant or machinery, which is the exception to 17.5D, the meaning is not given anywhere. So Mr. Arvind Datar said, they requested, the prayed to the court, that the phrase which is used in a law either should be defined in the same statute. If it is not defined, rather he said that it is not either defined in the General Clauses Act also. My dear friends, this judgment should be a case study with the I would say the legal education amongst the universities of the country. One of the case studies where the Honorable Supreme Court not only distinguished between these two phrases, but also guided the reader, guided the economy, that how a particular provision of the statute should be construed, should be interpreted. Out of 91 pages, they have dedicated 2 pages to reinstate the tools for interpretation of statutes. The tools are beautifully said, delivered by the Honorable Supreme Court. On the same line, I was referring to Advocate Arvind Datar. He said he requested to the court by way of his prayer that the phrase plant and machinery and the phrase plant or machinery are two different phrases. Plant and machinery is used in C. Plant or machinery used in D. Both as exception. If a particular work contract service is used to create plant and machinery, the credit shall be available. If the construction activity is done on my own account and a plant or machinery is created, the ITC shall be available. So, Mr. Datar said that these two phrases are different. 17.5 C and D, although looks appears to be same or similar, but they are different in at least two terms, two ways. One is this, that the exception to plant and machinery, exception to these clauses are different. One is exception, the first exception, the exception to first point C is plant and machinery, and exception to point D is plant or machinery. The expression plant and machinery is defined by way of explanation in 17.5, but plant or machinery is not defined. When there is no definition given for a particular term, phrase in the statute in which it is used, then the Honorable Supreme Court also accepted this, the prayer, that then in that case, the meaning attached to the word or phrase which is used in common parlance shall be acceptable. So what is plant in common parlance? What is machinery is common parlance shall be acceptable to understand or to attach a meaning which is going to be the meaning for this particular exception of 17.5D also. Now, what I was referring to, that they have given us 13 or maybe 14, 14 guidelines how to interpret a statute. They said in taxation statutes, justice and tax are strangers, or logic and tax are strangers. Such similar tools, such similar ways of interpreting statutes are given, around 14 ways, 14 aids, we normally call them in the student of laws language, aids to interpret. That is one part of the that particular case which would help us for future. Then Mr. Datar said that plant and machinery, now the question is getting clearer. I'm taking you to the slow and steadily, I'm taking you to the clarity or to the core of the issue which was being discussed by the Honorable Supreme Court. Bear with me for next 15-20 more minutes. I will take you to the core issue, the core of the issue. Exactly. Middle, center. Now, Mr. Datar said that the phrase plant and machinery is used 10 times in the law. 10 times in the law. But the phrase plant or machinery together is not at all used anywhere. And when the model GST law came, the term in 17.5 C and D, in both the provisions, the exception was plant and machinery only. But when the actual CGST Act came after the modern GST law, model GST law, the term plant and machinery in C remained as it is. In D, it was changed to plant or machinery. So Safari Council said that this is the situation. They presented before the court that this is the situation. In response to this, ASG said, Additional Solicitor General for Union of India said that, Your Lordship, this is a mistake which has happened on part of the legislature. They wanted to use the word and, but they used the word or. They admitted, ASG admitted on the open court that, and with the rejoinder also, that the law, the legislature wanted to use and, but they used the or, word or. To this, Mr. Datar didn't have to do anything. He did not require to reply even. The court, the bench itself was pleased to reply to this argument of Mr. ASG that Mr. ASG, had this been the case, almost 5 years has already passed that this judgment is pending before this court. If this would have been the situation that legislature would have done a mistake or an error, a mistake, they would have come forward to correct the mistake. They did not for 5 long years. Thereby, it clearly shows, look at what the cognizance, what Honorable Apex Court taken on record, what kind of cognizance of the conduct of the government they have taken on record. Therefore, we do not understand, we do not appreciate the fact that it is a mistake. It is an intentional, deliberate usage of the phrase plant or machinery. That's what they said it. Now, this is established that the word used plant and machinery is different than the plant or machinery. The definition which is there in the law for plant and machinery cannot be used to define plant or machinery. Therefore, now the next question before the Honorable Supreme Court was, what is plant or machinery? What is plant or machinery? So, in order to understand the word plant, they relied upon various judgments delivered by the Honorable Supreme Court only. Some of them are there, like one of them was the Taj Mahal hotels, Taj Palace hotels. In Taj Palace hotels, it was an income tax judgment. My humble view, let me tell you, it is in a very nascent stage. The way I read it, my team read it, may not be the way other professional or expert would read it or their team would read it. I am giving here, as I said at the beginning, I am going to use exact the verbatim words, the phrases used by the Honorable Apex Court. But yes, some of my views, the interpretations, observations, these are my own ones, my personal ones. So they relied upon 4-5 judgments of the Supreme Court. One of them is Taj Palace Hotels in case of income tax for claiming depreciation on building sanitary fittings. The sanitary fittings used in the washroom of Taj Palace Hotels, they wanted to claim depreciation over that. The case went to the Honorable Supreme Court to deliberate, to examine that whether the sanitary fittings would be eligible for qualifying as a plant or not. Honorable Supreme Court said that by way of this sanitary fittings, the hotel would be able to attract more customers and charge revenue and it will be what, of course, they said in a different manner, but if a GST guy would say so, it is in the course or furtherance of the business. Therefore, they allowed the depreciation on the sanitary fittings in the washrooms used of a hotel building. Then they relied upon Anand Theatre judgment. That was 2 judges bench, in which theatre building was not considered as the plant. But the similar issue was Karnataka Power Corporation was being examined by the Honorable Supreme Court. That was 3 judges bench, and it was Anand Theatre was overruled. So Karnataka Power Corporation is a good law, then the Anand Theatre, and they said it in the judgment also, the Honorable Supreme Court. So they said that at the end, on 90th page or 89th page, maybe, they said it that the following moot observations can be drawn from our judgment. And they started with it that for the purposes of availing the credit other than hotel and cinema building. So when they use this phrase, me and my team's observation is that hotel and cinema building are at the first instance itself the plants. Now the moot question here before the Honorable Supreme Court finally reached that what is plant? So they said that if a particular building is created which is essential for the service to be provided or the activity to be conducted, essential. The similar word was used for defining the online database access retrieval services definition, where there the information technology is virtually essential to provide it. Although from 22 Finance Act, the word virtually essential is removed. But essential means that without that, it would be very difficult to provide those services. If a building becomes plant, and for the purposes of making any building a plant, these tests are there, like Taj Palace Hotels, like Karnataka Power Corporation, like Aqua Plant, another judgment, wherein a specific building is created which is essential to provide a particular activity, to make particular activity. And next test which the Honorable Supreme Court went to give, or went to, I would say, design, that whether the plant which is created is essential and passes the functionality test. Plant is created, whether it is passes the functionality test, whether it is at most essential to provide the activity in which they are engaged. If it is so, now I'm going to, I'm now next 10 minutes, I'm going to sum it up, because friends, let me tell you, if it is plant, I have created the entire base. The Honorable Supreme Court, till now, let's recapitulate so that you be very clear about it. Till now, what has happened? Let's recapitulate. Odisha High Court said the credit is allowed. Went to the Honorable Supreme Court. Supreme Court said, okay, the term used plant and machinery, plant or machinery, these are the two exceptions. If first is not there because मैंने बाहर वालों से services ली नहीं, I did it at my own. At my own, it means other than other than if it is at my own, it means if it is used for the residential purposes, then at my own. That is what they have, the Honorable Supreme Court at my own. They have explained that what is at my own. If I have created the asset for using for my personal use, residential use, then it is at my own. Otherwise, it is outside that also. Largely, mota moti. Now, I'm recapitulating the entire process till now to make it crystal clear before you. Now, the credit is available if a particular inward supply falls into exception. Government says that plant and machinery, plants or machinery, one and the same thing, it is by mistake or used. Honorable Supreme Court said no, it is an intentional, deliberate use of the phrase or, not and. Therefore, we cannot take the definition which is provided in the law of plant and. We have to take definition of plant or machinery. So they had decided what is plant. If something, again, the chain is not broken. Honorable Supreme Court also stayed on the same fundamental which was designed by, which was being carried over till now through Odisha High Court, that the revenue stream should not be broken. Asset created, subject to tax. Revenue generated through asset created, revenue generated, subject to tax. Chain is not broken. Chain is not broken, falls into plant, passes the functionality test. Now they said, we cannot decide about whether this particular building, which is in question for safari retreat, safari people, mall, we cannot decide whether this building passes the functionality test or not. Kishore Bhai asked me this question somewhere else also when I was speaking before on the platform of MTPA, that why the Honorable Supreme Court sent this matter back to the High Court. They were deciding the facts, they were deciding things, they were interpreting things. They could have examined this issue themselves. My humble view, my little understanding, I'm a small person, I'm just a student of law. My view is that the Honorable Supreme Court wanted, first of all, a little bit of analysis of the facts of the situation also, which they wanted to be done by the original jurisdictional High Court, which read down those provisions or which allowed the credit. And also, they wanted that a particular guidelines on the basis of the exact set of facts should be designed by the High Court, and then matter shall go back. Listen to me carefully. Today, matter is going back to High Court. Around 1 month shall pass because all the original papers shall be returned back to the High Court. Everything. Then High Court will hear this matter. They will deliberate, they will examine further. They will design a particular guideline that how would a plant pass the functionality test? How would it be essential, at most essential, to provide the activity which they are involved in? Then thereafter, they will be sending it back to the Honorable Supreme Court. And then the final judgment shall be delivered by the Honorable Supreme Court. So this way, to my humble view, One, the factual analysis they wanted through High Court. Supreme Court wanted the High Court, to design or lay down a particular guideline for it. And then they wanted a airtight judgment, which cannot go beyond it. They must have felt that this is the genuine hardship before the taxpayer, and they should create a structure in such a manner that even if it goes to the larger bench, still it stays with its context, it stays with its soul. I could presume the purpose, the other experts or other thinkers may differ with my view, but I think it is going to be airtight judgment in times to come. Another, maybe if everything goes well, I am not able to predict at this time because courts are already heavily burdened with the cases. But what kind of importance and the sequence is given to this judgment, I don't know. But of course, another 6 months we may see that may be taken. So coming back now, Honorable Supreme Court what said? Kishore bhai, I think I have given the answer to the question, not only the previous one which you asked me, but today also when you asked a question before the start of the program that what is going to be delivered by the High Court. I am just predicting, sir. Of course, I am involved with the many the honorable the advocate who is representing this judgment, this case since 2018 at before on Odisha High Court. But of course, we cannot predict what is and it is a sub judice matter also, and we cannot say what is going to happen. We only be going through the directions of the Supreme Court before the Honorable High Court. What is going to happen, we really don't know. But as a thinker, as a student of law only, I'm predicting it. I am not sure about it. What is going to happen? The time has to give us the actual situation. Okay. So yes, one more thing which was being brought to my today only. Kishore bhai sent me few other information also, and this is there with us. 3 states he has identified. I think Rajasthan, Andaman Nicobar, and Puducherry. Am I correct, sir? Kishore bhai? Okay. Okay. Rajasthan at least is there. These 3 states, or I'll let you know the 3 states. He has given me the WhatsApp. In these 3 SGST statutes, in C and D, at both places. किशोर भाई आप अनम्यूट कर लिया, आप बताइए कौन कौन से स्टेट?
राजस्थान, जम्मू एंड कश्मीर एंड पौंडीचेरी.
अच्छा, अंडमान निकोबार नहीं, ठीक है. जम्मू कश्मीर एंड पौंडीचेरी. Okay. So these 3 states have different SGST acts. In these 3 states, plant and machinery in C and plant and machinery only in D. So maybe in these 3 states, the taxpayers may find it difficult to apply this particular judgment. And और भी किसी स्टेट में हो तो आप एक बार जरूर अपने स्टेट का चेक कीजिएगा, क्योंकि ये तो नेशनल प्लेटफॉर्म है and you must check before you apply. So word of caution. Okay, coming back. So of course now what is functionality test? This test is to be examined by the Honorable Odisha High Court. I feel almost at the conclusion of this judgment, I feel that I am being pushed back to my the opening statement with which I started with, where the Honorable Odisha High Court, on what basis they delivered the judgment. When a asset is created and that asset is put to use and generated revenue and subject to tax, that revenue is subject to tax. Therefore, it means that asset which is now considered, should be considered as a plant if it passes the test of the functionality, if it passes that it is essential to the provision of the activity in which they are involved in that case, the particular building passes the test of functionality and becomes the plant. The moment it becomes the plant, chain is not broken. It falls into the exception of 17(5)(d) and the credit is available. If you personally ask me, what are the specific instances? First of all, my humble view, it is again, now I'm repeating, it is my view. Hotel and cinema buildings, to me, according to the view of the Honorable Supreme Court, invariably are plants. This is my view. Please make it a point. It is already recorded also. I'm giving a clear, loud and clear disclaimer. So far as other than hotel and cinema buildings are concerned, if a particular building is specifically, now this is not there in the law, this is not there in the judgment. If a particular building is specifically created with some specifications to do a particular activity, like warehouses, a particular activity, it cannot be used anywhere, and the chain is not broken, passes the functionality, credit would be available. What would happen in case of plant or a building, rather I would say a building or a structure, special structure created to install a machinery? What would happen to that? My humble view, again, if that building is created or a structure is created without which the machinery cannot perform, and without that machinery, the activity for which the organization is involved in cannot be executed, it would pass the functionality test. Malls तो बड़े clear हो जाएंगे आपके. Warehouses are very clear. Even cold storages are very clear. But let the functionality test judgment come out by the Honorable Odisha High Court again. Then we will be, of course, this is my view, what I said earlier. Otherwise, in case of malls, if functionality, to me, ये बात मुझे ऐसी लगती है that Honorable Odisha High Court would qualify this building of Safari as plant. This is my view, because it passes the functionality. But I am expecting that the Honorable Odisha High Court will establish a principle, the guidelines to determine what kind of building or structure shall qualify the functionality test, thereby becoming the plant, thereby the credit is in. So let's, till functionality test, और मैंने वैसे, otherwise I have already given you my understanding and the understanding of the court, or apex court also, that how would it be. But again, the functionality test is nothing but of what was being said by the Honorable Odisha High Court in their earlier judgment, with which I started. So when you can make link the story with the, when you direct a movie and story is narrated in a manner where the first scene and the last scene are connected to each other or can take the inferences from each other, then it appears that the director was clear in his mind about his story from beginning till end, and he's successfully able to narrate also. That's what I have tried. That this is the beginning and this is going to be the end. Till now, the end has been functionality test. What is going to be the functionality test? Again, it is going to be linked with the beginning. Right, friends? So, apart from that, this judgment, as I said, is a very good judgment in terms of understanding how a particular term is to be examined. Like, I am overwhelmed with those 14 principles which have been laid down again by the Honorable Supreme Court to guide us how to interpret a statute. One must read it. So I believe this is it with respect to the entire spectrum. What has happened till now? What is going to happen now? I am going to deliver a case, a presentation in December at Cuttack, where this judgment is going to come. And hopefully by the time in December, when I would be delivering my presentation in Cuttack, Odisha, the Honorable Odisha High Court at Cuttack bench must have delivered already its judgment and guided the entire nation. How would the functionality test be passed to enable a building to be considered as plant to come into the exception to D, and credit would be eligible. Before I part with, so far as I rest my discussion, deliberation, of course, we are open for questions. I would like to tell you one more thing. 17.5C is talking about the inward supplies of goods or services taken from outsiders, not my own account. So service includes works contract service also. In D also, they have said goods or services. Service includes works contract service also. It is a deeming fiction as per Schedule 2 to CGST Act. Thereby, even if I take the credit of C as credit of D, I don't think so there is any restriction. I'm repeating. I have taken inward services of a contractor. This falls into C. But how would it not be falling into D also? Because the word used goods or services or both. And service includes works contract service also. And C is works contract service only. So why would C would not be included in D? If they have mistakenly used the word or, I think they must have mistakenly designed two different clauses for the same activity also. I don't know what is going to happen. How would court perceive this interpretation? But nevertheless, we do not require to go this extent. At present, the Honorable Supreme Court has made things a little easier, but this judgment is going to go a long way because the passing the functionality test would depend upon each and every case. It is not a generic benefit or a relief which is provided blanket to every case falling into 17.5D. No. One has to pass the functionality test. The principles would be laid down. So I believe it is individually, each and every case has to go through the functionality test. And this way, it may increase the litigation in times to come. Till now, we did not take the credit. Now the hope is there to take the credit. Taxpayer also would approach all of us, take the credit, but it is a double-edged sword, to my view. One need to be very careful. Blindly, blanketly, the credit should not be taken, availed or utilized. Although merely availing, not utilized, would not, uh, you know, entailing the interest, but yes, they may allege for penalty. Yes, they are, that you have taken a credit in your credit ledger, you have not availed it, no interest, but they are alleging for penalty. So therefore, you before taking this credit as a taxpayer, every professional must be very careful, thorough, and re-examine in determining this fact that whether the credit is available or not, credit would be available or not. Now, I think that's all from my side with respect to the analysis. Now we are open for, as per the directions of the organizers, for the queries for next 10-15 minutes, whatever it is, whatever the queries are.
सर बिफोर स्टार्टिंग एनी क्वेरी एंड क्वेश्चन आई विल मुझे थोड़ा सा सवाल ये था still now we had not taken any credit from 17 to till date. Already times have gone. Functionalities test is passed. How to go about this?
Now, if you have not taken the credit must have been capitalized and the depreciation must have been availed. So thereby another post availment credit of 16.2, post availment condition of 16.2 is failed. Either you can take depreciation on the tax part or the credit of the ITC. So now you better know, sir, I am to do not practice in direct taxes at all. And the balance sheet is, 10-15 years have been away from me. I do not file my income tax return myself even. So, sir, I'm unable to comment upon whether you would be able to revise your balance sheet, revise your audit report, and segregate the ITC from the fixed asset, and then I don't know what is going to happen.
No, that is not possible, sir. But this case can be possible, in the case of work in progress, like type of situation.
Sir, वहां तो there is no problem. वहां you ask that it is already, the credit is not obtained, taken. अब अच्छा work in progress में now
Like
another
I fled the book or something like that, and I
Another-
already paid GST too for part. And on
another
completion of
limitation
the
which will come before you is 16.4.
yeah, that is the main issue.
So if 16.4 timeline is gone, so the credit you
Lapse.
cannot avail the credit. Whether it is available or not, that is a separate question. But you cannot avail it at all now.
Yeah.
So that avail will come to play.
Okay, any participant have a question can raise the hand. I can unmute. Okay.
Kunal Dabda has raised the hand.
Hello.
Yes,
Kunal, you are
Kunal ji.
audible.
Yes, sir. Owing to our discussion, as you said, so just we can we summarize that just because the goods and services are used for construction, say warehouse or anything, and for rental purpose, etc. So even then we'll have to require the two conditions should be satisfied. That is the functionality test of, say, it should be a plant. That should be.
Sir, now the guidelines have been devised by the Honorable Supreme Court. Irrespective of the situation, credit is available or not, but every situation
Will be available
has
for
to
ITC.
go through,
The functionality
Yes.
test as well. So
Yes.
it is not a blanket that if just for rental we'll get the
No,
credit.
no,
It should
no.
be for the functionality test.
No.
But sir, then how to prove the intention, or at what time do we say that it is on own account? Say at the time when if the say builder or developer is purchasing goods or services for building a warehouse, etc. Now
Hmm.
they are is their intention to say give it on rent. So they have constructed this mall or warehouse, and they had the intention to give this on rent. So it can be said that is not on his own account. They have
Yes, you
availed
can say.
they have availed the full ITC, and say after 1 year they are selling this whole property. Then what is the scenario? Because
The ITC which you have already availed. Now, if you are selling the property, on that you will not be charging the GST.
it would be after OC period.
Yes.
Not under construction.
Now the credit which you have already availed.
So
You tell me in normal scenario, for example, you are into construction of immovable property. You got the property constructed, but you did not take any single rupee as advance before the OC comes. It would not be subject to tax.
Yes.
Yes, sir, Krunalji. It would not be subject to tax.
if I've not availed ITC, you are saying?
Yeah, no. ITC is separate matter.
Okay.
If you are selling the property completely and do not receive any advance,
Yes, so it will
not be
not
subject to
not be
tax.
subject to.
Would you be allowed to accumulate ITC?
Not in that scenario.
Similarly, in this scenario also, if you have constructed the property and put it on rent, and now the ITC you have availed and adjusted against rent, if now there could be two ways to understand it. The input tax credit, if it is becoming plant, so section 18(6) shall apply. If it is for use for 5 years, and after 5 years you are selling it, in that situation the tax would not be reversed, the input tax credit would not be reversed at all. This is my view immediately. I may be requiring to analyze it later because it is just at a very nascent stage.
I understand, sir.
So in that case, if you use it the property for 5 years, and it is mentioned, it is somewhere referred also by the ASG as well. So in that case, if you sell it before 5 years, the proportionate credit would be reversed.
But then I agree, sir. But 18(6) is using the words capital goods, and goods will not include this immovable property. If I can understand if it's passing the functionality test as a plant, then we are taking ITC. But for 18(6) to apply, it will be capital goods, and goods would define any kind of movable property and not an immovable property. That was the concern, basically.
Okay, I need to check then 18(6) again. What is the phrase? What is the term used? But it is nothing but of, you must have capitalized these building also in your books of accounts.
Yes.
Even if it is written capital
Immovable
goods.
property. Yeah.
So passes the test. So that way it would be, maybe, but we need to analyze the facts individually, but apparently which appears to me that you need to reverse the tax, the input tax credit availed already.
So in that case, it will not be a transaction value tax has to be paid on a transaction value. because it is high, more than the purchase value.
Sir, 18.6 says the remaining input tax credit or tax on the transaction value, whichever is higher.
Yeah.
Tax on the transaction value would be 0 because it is sold. It is sold as an immobile
Immobile
property.
property.
So the credit reversal would be required. And we will not go for the transaction value or the tax on the transaction value.
If it falls under 18.6, capital goods basically.
But
That
sir,
should
when
be
I
analyzed.
sell as a plant,
So that is the issue. We are taking ITC on the basis of this judgment as the plant, but
and
then
we
it
are
is sold
selling-
as an immobile property. So
We
that's
You
are
the
cannot
selling
have
animal
you
property.
cannot have apples in the both hands, sir.
That is what the issue is.
yes.
When you have apples in the both hands, it is difficult to eat, sir.
True.
It may swell your stomach as well. किशोर भाई आपका हाथ उठ गया मतलब I should stand up.
One more thing is there. Can I say, Arjun bhai?
Before you, Kiran sir, Kishore bhai is to be.
Okay.
Kishore sir, you are on mute.
Yeah. See, by expanding the definition of this plant, if suppose the tax consultant में suppose अरोरा जी आप ही suppose एक खुद एक मटेरियल लेकर एक 2-3 फ्लोर का बड़ा बिल्डिंग बना रहे हैं जिसमें आप टोटल लीगल कंसल्टेंसी सर्विसेज देंगे, ऑल टाइप्स ऑफ लीगल कंसल्टेंसी, और आपने 10-12 एडवोकेट रखे, 10-12 सीए रखे, आईटी किया, सॉफ्टवेयर किया, कॉन्फ्रेंस रूम, ट्रेनिंग रूम, पूरा इंफ्रास्ट्रक्चर उसके एंगल से ही बनाया. So you are paying tax on the sale side by charging 18% on your services. So in this case, will you not get ITC? By
To me,
expanded
no.
definition of plant.
To me, no. ये बात MTPA पे भी हमने डिस्कस किया था सर, जब आंचल मैम थी हमारे साथ, तब मुझे याद है, आई मस्ट गिव क्रेडिट टू हर, तब उन्होंने भी ये बात कही थी कि मैं फिक्सचर फर्नीचर का एग्रीमेंट सेपरेट करूंगा और वर्क्स कॉन्ट्रैक्ट का एग्रीमेंट, कंस्ट्रक्शन का एग्रीमेंट सेपरेट करूंगा. तो जितना मेरा फिक्सचर, फर्नीचर, एयर कंडीशनिंग, कंप्यूटर, ये सब का क्रेडिट तो मुझे मिल ही जाना है. सो बिल्डिंग एज सच अगर मैं उसको टोटल कम्बो कर दूंगा, देन इट वुड बी डिफिकल्ट for me to establish, sir, that it is a functionality, the functionality test and becomes the plant. So that way, sir, उसको segregate करके तो मैनेज हो जाता है, जो कि आज भी हम कर ही रहे हैं सर.
Okay. Thank you.
सर easier ना सर, क्यों झंझट लेना है सर?
नहीं, क्योंकि वो फिगर बहुत बड़ी होती है ना आईटीसी की.
सर मतलब आज मैं I appeared in a case where the tax amount was for 200 crores and the taxpayer was paying tax. 6 years ago I gave an opinion that it is not taxable, it is zero rated supply. It was still paying tax. Listen to me carefully, it was still paying tax. Today the investigating officer said that when you are exporting, when you have a zero rated supply, then why did you continue paying taxes? I said, this is a MNC client and they did not want to take any chance. This is my opinion, which I gave 5 years, 6 years back. So that also gives, you should always be on the right side of the law. Whatever law permits, do it. Should not be a sadhu here. One should be very practical. And one should not be above board also. To me, Kishore bhai, I don't take pangas. Wherever things are there with me, okay, go ahead, I will not stop. Even if the client says, I say, okay, I'm telling you this, it is your call. Now today the matter is sent to Sweden itself, that Mr. Arora 5 years back told us that it is not taxable. We paid 200 crores here, and now department is saying this is not your export, and we are We are asking, they are asking them to return the DGFT benefit of 70 crore they have taken, import license, SCIS. Now see what is the impact if they would have understood and agreed to what we said. 200 crore भी बचते, आज 70 crore का और स्यापा भी ना पड़ता. So that way, today it is very, sir, Kishore bhai, it is, frankly, I am admitting that it is a very, very narrow path on which we are walking today with respect to safaris. So I'm feeling suffocated, sir. Otherwise, मैं इतना जो है, I come above board और मैं front foot पे खेलता हूँ GST में. So when Krunal's question came, so you find me very quite less when I use I speak on it only. I do not use fillers. But today I had to think what is going to happen. So it is something like that only, sir. I don't want to take any chance, sir.
Okay,
You are
Kiran
big
bhai.
people, sir. Sangli people, sir. You can do anything, sir.
Okay, Kiran bhai, your question.
Yes, sir. There are two different situations. फर्स्ट सिचुएशन है जहाँ पे मैंने फैक्ट्री लैंड के ऊपर कंस्ट्रक्शन करवाया था. कंस्ट्रक्शन के लिए जो भी आईटीसी लगा था वो जीएसटीआर 1 में मैंने, जीएसटीआर 3 में मैंने एक्यूमुलेटर आईटीसी बताया. एंड प्रीमाइसेस इज गिवन ऑन रेंट टू वन ऑफ द फैक्ट्री ऑनर. और अभी भी आईटीसी मेरा वहां पे दिखा रहा है, और हमने जितना भी रेंट के ऊपर आईटीसी कलेक्ट किया है उतना पे कर दिया है. Nowadays, in the light of this safari judgment, can we claim that ITC now? I have accumulated my ITC in GST 3B right now.
किरण भाई, ये है क्या?
फैक्ट्री को
कंस्ट्रक्शन किस चीज का किया था आपने?
एक पर्टिकुलर ऑनर को फैक्ट्री चाहिए था, वो फैक्ट्री हमने प्लांट बना के दिया, पूरा मशीनरी एंड सॉरी नॉट मशीनरी, पूरा बिल्डिंग उसको उसके डिजाइन के हिसाब से बना के दिया है.
उसके डिजाइन के हिसाब से बना कर दिया है.
हाँ, डिजाइन गिवन बाय द फैक्ट्री ऑनर. प्राइवेट लिमिटेड कंपनी है, उसका ऑनर ने डिजाइन जो सप्लाई किया है वो हिसाब से हमने पूरा फैक्ट्री प्रीमाइसेस कंस्ट्रक्ट करके दिया है. एंड लेट आउट पीरियड इज अराउंड 9 years फॉर दिस ईयर.
9 साल हो गए?
नहीं, अभी तो फर्स्ट ईयर कंप्लीट हो रहा है
अभी तो टाइम है.
हाँ, तो फैक्ट्री का प्रीमाइसेस बन गया है. आईटीसी जो भी था वो एक्यूमुलेट करके जीएसटी 3B में बताया है. 2 बार ऑफिस में
एक्यूमुलेट तो किया है ना,
लेकिन किया नहीं है.
एक्यूमुलेट तो किया है ना.
एक्यूमुलेट किया हुआ है.
देखिए सर, वेट टिल सफारी उड़ीसा हाई कोर्ट कम्स बैक.
ओके.
Then you should speak with me later at that point of time.
Okay,
I will seek some other facts from you, and then on the basis of this judgment, I will tell you. अब आपके पास कुछ करने को नहीं है, अभी आप बस उसको as it is, अभी जो आप रेंट पे टैक्स कलेक्ट कर रहे हैं दे दीजिए.
ओके.
अभी जैसे आप कर रहे हैं ना, you continue doing so, sir.
Okay. In second,
Wait till 1 or 2 more months, and
Okay.
the mist will be clear.
Yes, got it, sir. In second situation, कॉमर्शियल कंस्ट्रक्शन प्रीमाइसेस हमने रेडीमेड परचेस किया है, जहाँ पे बिल्डर ने सेल आउट किया है और हमने परचेस किया है विद पेमेंट ऑफ 12% जीएसटी. एट दैट टाइम ऑफ परचेस वी हैव परचेस इन द इंडिविजुअल नेम एंड देयर वाज नो रजिस्ट्रेशन टेकन बाय द एसएससी. आज की डेट में उसको रेंट, उसका पहले से इंटेंशन था एट द टाइम ऑफ परचेसिंग ऑफ द प्रीमाइसेस दैट इट विल बी गिवन ऑन द रेंट. इन दिस सिचुएशन आल्सो 5 years रेंटल एग्रीमेंट इज ऑलरेडी डन. As soon as OC received, very second day we have given it on rent. और हमने रजिस्ट्रेशन अभी लिया है क्योंकि रेंटल का जो रजिस्ट्रेशन था वो हिसाब से हमने आफ्टर गेटिंग OC रजिस्टर आवरसेल्फ फॉर द रेंटल एक्टिविटी. मेरा वहाँ पे एक्यूमुलेट नहीं किया है, ना मेरा वहाँ पे B2C में अपना B2B में कुछ दिखा रहा है क्योंकि हमने वो टाइम पे रजिस्ट्रेशन नंबर दिया नहीं था, ना हमारे पास था. तो आज की डेट में उसको चेंज कर सकते हैं या उसको आईटीसी को हम लोग यूटिलाइज कर सकते हैं. उसमें
कब लिया था रजिस्ट्रेशन?
रजिस्ट्रेशन लिया है अप्रैल में 24 एंड प्रीमाइसेस परचेस किया है जनवरी 24.
तो एक आईटीसी 01 फॉर्म जाता है.
ओके.
उसमें आपके पास एक्यूमुलेटेड आईटीसी ऑन अकाउंट ऑफ गुड्स और सर्विसेज क्या होता है, वो भी सेक्शन 18 की कहानी है। आप उसमें से वो पढ़कर एक बारी आईटीसी 01 फाइल करके क्रेडिट एक्यूमुलेट कर लीजिए।
ओके सर।
फिर देखते हैं आगे क्या होता है। आपको भी जवाब वही है, पहले सवाल वाला जवाब दूसरे
अगली
सवाल में
जब
भी
वही
है,
है।
लेकिन एक एक्स्ट्रा आपको एक्टिविटी अभी बता दी, वो कर लो,
यस सर।
वो कर लो। बाकी सेम दवाई थोड़ी देर में लगेगी।
थैंक यू राजेंद्र जी।
Any other question?
सर बार इज अबाउट टू क्लोज, तो not the other bars are about to open, this bar is about to close.
Yes sir.
Yeah, anything else? Participants, query?
Girish Rathi is wanted
Girish
to
sir.
ask question.
Girish, mute है.
So Rajendra ji, there is one my client is there who is giving. I'm audible, na?
Yes,
Yeah.
yes, sir.
Please go ahead.
It is giving billboards, advertising boards on hire. So उसका rent आता है, उसके ऊपर GST बढ़ता है. But then to construct that advertising board, iron and steel and cement का structure बनाते हैं. वो structure के ऊपर हमने ITC लिया हुआ है. But now it is in appeal. So whether will I get it or not? तो सीमेंट का स्ट्रक्चर बन जाता है, पिलर बन जाते हैं, उसके ऊपर मतलब 25 फुट का ए बनता है और उसके बाद एडवाइस का रेंट पे आता है।
वो एक ना मुझे एक गजल याद आती है सर।
इरशाद।
वो मैं पूरा फर्स्ट मुखड़ा नहीं याद कर पा रहा।
जी करवा देंगे।
वो हाँ जी हो जाएगा। वो कहते जी, वो कुछ यूं था, तेरे आने से मैं, मतलब मैं तन्हा था मगर इतना नहीं था, तेरे आने से मैं कहते हैं ज्यादा तन्हा हो गया, पहले भी तन्हा था लेकिन इतना तन्हा नहीं था। तो मैं परेशान था मगर इतना परेशान नहीं था, तुम्हारे आने से ज्यादा परेशान हो गया। तो कहीं ना कहीं ये जो मैटर है, देखिए प्रिंसिपली आपका जो स्ट्रक्चर है, अब वो वर्क्स कॉन्ट्रैक्ट का तो कोई क्रेडिट नहीं देते ना ये लोग जो हैं।
यस।
और आपका वाला केस तो जो है वो पूरी की पूरी जो वो जो व्हाट यू कॉल दैट, आपने क्या बोला, टावर्स,
टावर्स खड़े करते हैं।
टावर्स जो है वो तो लगते ही उस स्ट्रक्चर के ऊपर है, बिना उसके तो वो यूज ही नहीं हो सकता, दैट इज प्लांट इटसेल्फ। सो टू मी प्रिंसिपली प्राइमरीली इट वुड पास द टेस्ट ऑफ द प्लांट।
यस सर। और वो बेस पे
तो
ही क्लेम किया हुआ है।
स्टे रेडी सर टू सेलिब्रेट समटाइम्स।
चलो थैंक यू।
अभी जो किरण जी बोल रहे थे कि द क्रेडिट इज नॉट accumulated in case of this property, तो दूसरा वाला क्वेश्चन था। अब सर 2018 में जब ये when this judgment came, so we whosoever approached me, I got the credit accumulated and it is around now 650 crores.
Oh.
But sir, you are saying that they are levying the penalty for
Sir.
accumulation and not utilizing.
सर जहां पर आपको चिट्ठी नहीं आई कोई, जहां आई वहां पर हमने कहा हमने अवेल नहीं किया, और they are not levying, they could not levy it till now, they are alleging, I use the word alleging,
Yeah.
और they allege quite frequently कि यहां पर आपने ये गलत। अब आप सोचिए ना, आपके टूए में क्रेडिट नहीं आ रहा, उन्होंने पेनल्टी अलेज कर दी। I have everything, now the supplier is not able to correct its one now and it is not appearing in my 2A, but I have availed the credit. Circular 183 and 193 I am not able to avail because the supplier is not giving me the certificate. Now they are alleging me the penalty also.
Correct.
Will it survive? No, answer is no. एंड जब सर बात 650 करोड़ रुपए की होगी, या मैं कह रहा हूं 650 क्या 1 करोड़ रुपए की भी होगी, तो आई विल कंटेस्ट द पेनल्टी टूथ एंड नेल।
Stake involvement.
Yes sir, so that way.
सो जो जीएसटी में बोलते हैं ना, मतलब जीएसटी गलती सब टैक्स पेयर की, गलती सब टैक्स पेयर की,
गलती सब टैक्स, सिर्फ सब टैक्स पेयर की।
जीएसटी ऐसा है।
अभी सर देखिए, आज हम बात कर रहे थे, yesterday there was an advisory issued by GSTN with respect to auto filled 3Bs, form GSTR 3B, from GSTR 1, 1A, IFF and 2A, 2B auto filled, and January 25 onwards the taxpayer would not be allowed to alter the auto filled details also. And we were discussing in the bar today, now the taxpayer has started thinking, now we do not need an accountant or an advocate or a chartered accountant to fill the form. It is already pre-filled. But pre-filled data, how pre-filled data comes? Through 1, through 2B, 2A, 2B. Who is going to do that? Your Chacha ji? Now Gali ka bachcha who is able to file the GST return is grown up. Not that even Gali ka bachcha is not required to file the returns. It is done by the artificial intelligence itself. But what is the origin of the data? That origin of the data has to be monitored by a professional. Otherwise, garbage in, garbage out.
Garbage out. True.
Simple. So that way, ठीक है sir, मतलब this is part of life. One should not be serious, should be sincere. We should not be attaching much value to it. ये सब मिथ्या है, माया है sir.
Yeah, any other question? I think sir has explained Safari in a very lucid and इतना अच्छा समझाया है कि किसी को कोई query नहीं बचा है अभी. So straightway we'll go Manoj bhai from Tax Friends to propose a very reserved vote of thanks to Rajendra sir. Manoj bhai, over to you.
Is it there?
Yeah, he's there.
Kindly unmute me, sir.
Yeah, you are unmute, sir.
So respected, thank you, Rajender Sarji, and respected members, presidents, and all the committee members of associations, and my dear participants. I would say the realm of real estate is undoubtedly complex, and when it intersects with the intricacies of the ITC claims, the challenges only multiply for us. So today's session addressed by Mr. Rajender ji on this critical topic was not only insightful for us, but also exceptionally clear and comprehensible. I'm sure we all agree that our distinguished speaker, here, Rajender Arora, has explained this subject with great clarity and depth. On behalf of Tax Friends Association Mumbai and all the delegates and associations represented here, it's my privilege to extend a heartfelt vote of thanks to Sir Rajender Arora for sharing his valuable insights and enriching our understanding on this significant issue. We are deeply grateful for your time and your contribution, sir. Thank you very much, sir.
Thank you, Manoj bhai. And with the permission of all the president and chairmen of all the association, I declare this meeting, Zoom meeting.